All right, sir, you're Calvin Randall. And Mr. Eckhart, will your client waive the formal reading of the indictment in each case?
We do, Judge.
Mr. Randall, in cause number 24, DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises, and I don't know what all those other letters stand for. IATWFZ.
That's the statutory name, Judge. I think it's in a correctional facility or something like that, but it's not applicable here.
Just, I'm looking at the indictment. It says unlawful carrying weapon, alcohol premises, IATWFZ.
I've seen that before.
Weapons-free zone.
That's what it is.
Thank you. In a weapons-free zone. All right. And that is from May 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in cause number 24, DCCR 1530, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection in each case.
It's admitted in each case. Is there any evidence that Mr. Randall is not competent?
No.
All right, Mr. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence to find you guilty, and in cause number 24, DCCR 1529, finds you guilty of evading arrest or detention. Good grief. That one is the unlawful carrying of a weapon on alcohol premises. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1530, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These two sentences will run concurrently, which means together at the same time. I will sign as a part of this plea agreement the dismissal in cause number 24, DCCR 1278. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. Did I do, I don't think 1529 came through. Would you?
Yes, ma'am.
They're going to, so also I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Eckhart. All right, good luck to you, sir. And we're going to get that other one printed out in just a second. Oh, it's... All right, thank you, sir. You can go back with the bailiff. We'll get it to you. Good morning, sir. Are you Jaquan Fontenot?
Good morning, yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
And you guys have agreed to go on...
1, 2, and 3, Judge.
Mr. Fontenot, in cause number 22-39248, I have a first amended motion to revoke your unadjudicated probation, and will he waive the formal reading of that?
He will, Your Honor.
It shows that you were placed on probation December 14th of 2022 for the offense of theft of a firearm, a state jail felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department July 17th, July 23rd, and August 20th, and September 23rd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to pay your court-assessed fees as directed, and that as of September 23rd, 2025, you were $3,505 behind. Is that true or not true?
True.
And then count 3 alleges that you committed the offenses of possession of marijuana, resisting an officer, and no insurance on September 9th of 2023 in Calcasieu Parish, Louisiana. And is that true or not true?
True.
And the state's going to abandon the rest?
Yes, Your Honor.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence that Mr. Fontenot is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Relatia Mouton?
Yes, ma'am. Good morning.
Good morning. And Ms. Mouton, I'm going to take judicial notice of the court's files in Ms. Mouton's cases. We've got clause numbers 25 DCCR 0907, 1446, 1467, and 1468. Ms. Mouton was examined for competency to stand trial by Dr. Capon. I have received that report dated September 29th of 2025, and the finding in that report is that Ms. Mouton is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Rojas?
No, Your Honor.
Mr. Smith?
Understood.
Then at this time, based on that report, I am going to find Ms. Mouton competent to stand trial. And Mr. Rojas, what is the announcement then?
Judge, can we get one more announcement? I'm going to need some time to go over the rest of the discovery with Ms. Mouton.
Sure, we'll just do a normal reset. Ms. Mouton, Mr. Rojas will be out there to go over everything that he has received, and then you guys can make a decision on what you want to do with your cases, okay? You can go back with the bailiff.
Thank you.
Yes, sir, thank you. Good morning, sir. You are Asa Joseph Jones. In clause number 25, DCCR 0963, you're charged with aggravated assault, discharging a firearm recklessly. That's from June 12th of 2025, and that's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 25 years in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject this offer and have your case set for trial?
Yes, ma'am.
All right, I'll get that done. As far as you know, all the discovery, you have everything?
I have everything.
Okay.
And we're not waiting on anything, Judge.
And is there any reason to believe that this offer would change, Mr. Coleman?
Not at all.
I want to make sure you understand, Mr. Jones, that after today, this offer will be off the table. If you change your mind later and want to enter a plea of guilty, you could do that open to the court or to some other plea agreement. But after today, this one's off the table. You understand?
Yes, ma'am.
Okay, we'll get it set for trial. Mr. Burbank will begin preparation.
Thank you.
Thanks.
I'll be out to see you.
Where facts meet emotion, justice finds its voice. To witness more real courtroom moments, subscribe to Law Nexus.